Hello and welcome back to the another lecture of today's. Well, as you can see here on the screen, this is about Indian polity. You know, this is the lecture 10 of Indian polity. Before we'll start our discussion, I would like to give the brief introduction about the initiative so that if you are new to our channel, you will get connected with us. Basically from 2nd June, we had started an initiative here, and we can say the name of the initiative is Target IAS 2026. So under this initiative, every day we are uploading two videos on our YouTube channel. In the first one, we discuss the current affairs, which is in the morning session. We take up the most important articles from the newspapers and discuss them with respect to your prelims preparation as well as mains preparation. And in the second video, we discuss the static syllabus. So under this static syllabus, we had started with Indian polity, as you can see here, and this is the 10th lecture about Indian polity. And one more thing I would like to add here that, as we had promised you by the month of Jan 2026, we are aiming, we will try our best to cover your syllabus, and under that, we will try to cover every subject which you require to study for qualifying the exam. We will try to cover every subject, whether it is related to prelims or mains. We'll try to cover every concept what is required for you to have that concept, to have the clarity over that concept to cover to qualify this exam. We'll try to cover everything, but there is an exception. What is that exception? That we are not going to conduct the classes for your optional. So for that, you would have to consult some coaching institute. Maybe you would have to pay for that. That is your concern. But optional classes we are not going to conduct here, except optional classes and language classes. Everything would be conducted here. Every concept would be discussed here. Every book, every subject would be discussed here. This is our promise from our side. So in this regard, for your preparation in this journey, you would need notes also. You would need these lectures also. These lectures are freely available here, but for the notes, what you will have to do, right now we are discussing Indian polity. At the same time, we are making notes of Indian polity, and these notes would be very much different from the other notes which you get from the market, or from the books which you get from the market. These our notes would be very much different, because they will contain all the concepts required. They will contain the questions related to those concepts with respect to prelims as well as mains, and they will explain you everything there. So these notes, we are preparing these notes with respect to the classes which we take. Right now we are taking Indian polity, and these notes would be available once we will complete the full syllabus of the subject. For example, once we will complete the full syllabus of Indian polity, the Indian polity notes would be available. But for these notes, you would have to pay only 200 rupees. It is up to you. If you want to get access to those notes, please do consult us. We have given our email ID. You can mail us, and we will then further deliver to you what you require. So this is about the initiative. If you want to be the part of us, if you want us to be the journey, if you want us to be the part of your journey, so please let us do subscribe the channel, do share it with your friends, and do write in the comments what else should we bring for you guys. So this is in a nutshell about this initiative. Now, without any delay, let's have a look at the topics which we have to discuss today. From last few days, I guess from last 4 lectures now, we are discussing Indian polity. We are discussing fundamental rights. From last 4 lectures, we are discussing fundamental rights. And about fundamental rights, we saw that, it contains fundamental rights. It contains different types of rights, and we elaborated it in our first lecture. So here, what we discussed so far, we discussed the right to equality. We discussed this contained under Article 14 to 18. We discussed them in a very detailed manner with examples, with judicial verdicts. We discussed everything related to these articles in our earlier classes. And after that, after right to equality, we started discussing the right to freedom. And under right to freedom, we have Article 19 to Article 22. We discussed Article 19 in our previous class, and also Article 20. Now we have to discuss Article 21 and Article 22 from today. About these articles, what we had seen so far, they have one thing in common. What is that thing in common? they have the reasonable restriction in common. And we saw in under article 19 how many reasonable restrictions are there, how many exceptions are there. So with respect to this article also, we will discuss those, and we will discuss it in a very detailed manner. First we will look at the context, first we will look at the language of the article 21. What does it say? Let's have a look at it, then we will start discussing it. Here the article 21 of the Indian Constitution, which is the fundamental right, it states that no person shall be deprived of his life or personal liberty, except, what is the exception here? Except according to the procedure established by law. So what does this article say? No person shall be deprived of his life or personal liberty. So in general, article 21 is about the right to life and personal liberty, the right to life and personal liberty. And what is the exception? Procedure established by law. So article 21, it is about right to life and personal liberty, and exception is procedure established by law. Again, I would like to read the article here. No person shall be deprived of his life or personal liberty except according to the procedure established by law. Now here in this article we saw that right to life. Now the question is, what is this right to life? What is this right to life? Right to life, does it mean just the act of breathing? Does it mean just the act of breathing, or it has some wider understanding in it? So this question when asked to the Supreme Court, they said that the right to life, it does not only mean that you have this right that you can breathe only. It does not mean the physical feature. It does not only mean the physical act of breathing, but it has a wider spectrum. We can interfere many, we can infer many things from this article. And so it has been done by the judiciary through the principle of judicial creativity. By invoking the judicial creativity, they had inferred many rights from article 21. Like here we had given you here that we have we have right to clean environment. In article itself, right to life or personal liberty, it does not contain the right to clean environment, but it is the judiciary which said that if you want to enjoy the right to life, if you want to have the full potential of right to life, you also need for that there should be the clean environment where you can enjoy your life. You don't want to get sick, you don't want to get infected. So for that you need to have the clean environment, and having this clean environment comes under this article 21 of the Indian Constitution. It is the fundamental right that every person needs a clean environment. Similarly, right to health and medical care, you can have the right to life, but you may fall sick, you may meet an accident. For that you need the health care, you need the medical care. So to have this health care and a medical care, it is also a fundamental right to you. Similarly, right to free legal aid. You may get arrested, and you may be poor, you need some you may need a lawyer to represent you. If you are poor, how you can be represented? Then the state will come in, they will provide you the governmental lawyer for that. So you need a free legal aid. It is the fundamental right of every person under article 21 to have free legal aid. Similarly, about the speedy trial, similarly against solitary confinement. You don't want to be in the jail and be in a solitary confinement. You want to be, even if you had done anything wrong, but you still want to socialize in the jail. So this is your right. You can't be put into a solitary confinement. But definitely, even if the Constitution has given you all these rights, even if the judiciary has interpreted these rights for you, but still these rights are not absolute. They are not absolute. There is a reasonable restriction to these rights. There is definitely the reasonable restriction to these rights. So this is about the article 21. till now what we understood Article 21, it is about no person shall be deprived of his life or personal liberty except according to the procedure established by law. But here, is it only bare breathing of the person? No, it has wider scope. You want to live with the dignity, it should be given to you. You want to have a clean environment, it should be given to you. It is a fundamental right to live this, to have this right to life and liberty. It contains the wide spectrum of rights which you should be made available to. Now let's try to understand, and also at the end we understood that it has a reasonable restriction. Now let's try to understand what is the significance of Article 21. Why does it stand with respect to the fundamental rights? Let's try to understand that. But first, to understand that, let me rub the board here. So Article 21, let's suppose we discussed the fundamental rights. We discussed right to equality, we discussed Article 14, we discussed Article 15, Article 16, Article 17, Article 18, Article 19. We saw that there is right to freedom of speech and expression. Suppose there are all those rights are there, you have all the rights, you have there is equality before the law, and there you have there is no discrimination on the basis of religion, caste, sex, or residence, or all that what we discussed so far. Suppose there is absolute untouchability. Suppose the Article 18 is there. Suppose you have the freedom of speech and expression, but all those rights are absolute. But there is one exception. What is that exception? There is no Article 21. There is no right to life and personal liberty. There is no right to life and personal liberty. Now let's look at those rights. How will those rights reflect your life? Even if you are given the freedom of speech, but you are confined in the jail, your personal liberty is confined, your personal liberty is removed from you. Can you enjoy all those rights? No, you cannot enjoy all those rights, even though all those rights are there and they are absolute. But you don't have the right to life and personal liberty, you don't have Article 21, then you cannot enjoy all those rights. So this Article 21, what is it? It is the soul of the fundamental rights, or we can say it is the soul of the Part 3 as well as Part 4 of the Constitution. Without Article 21, your life would be hell. Even if you would be given everything, if Article 21 is not there, police can come to your home and arrest you, put you in the jail, and you will not even see the court. You would be in the jail forever. So definitely there would be concerns. You cannot enjoy it. Now let's assume. Now reverse our discussion. Now let's assume there is only Article 21 and no other rights under fundamental rights. Suppose there is only Article 21, there is no Article 14, no Article 15, no Article 16, no 17, no 18, no 19, no 20, no 22, 23, 24, all that. Just only one right is given, that is Article 21, which is the fundamental right, and which says that you have the right to life and with personal liberty. You have, which says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now let's assume what would be the condition of you. As we had seen that judiciary, it has used its creativity. We did not have the right to privacy till 2017. It was not considered, even though we had the right to privacy, but it was not considered fundamental right. But in 2017, by the Pothuswamy judgment, it was recognized as a fundamental right. Similarly, by the judicial creativity, all those rights, for example, right to freedom of speech and expression, it would have made the fundamental right by using the Article 21, by using the scope of Article 21, that if right to life and right to life and personal liberty does not only mean bare breathing, it also means that you should live with dignity. How you can live with dignity if you can't speak? So right to freedom of speech and expression would have been made the fundamental right. Similarly, all other rights would have been carved out of Article 21, would have been inferred by the judiciary from the Article 21. So in a nutshell, we can say the significance of Article 21 is that it is the soul, and it is the soul of the fundamental rights as well as directive principles, or we can say soul of Part 3 and part 4 of the Indian Constitution. Now, till now, I hope you had understood what Article 21 is. Article 21, it talks about the right to life and personal liberty. It does not only mean that we are breathing, just you are a living human being. It does not only mean that you need to live with dignity. You need to have a clean environment. You need to have the health and medical care. You need to have a free legal aid. You need to, you need to have a shelter. You need to have an education. You need to have a reputation. You want to marry a person of one's choice, but this is under, after the, judgment in 2024. It was made that it's not a fundamental right because of the judgment by the judiciary. So that is different. We will discuss it when we will take up. Actually, we had discussed this in our last class. When in our last discussion we had discussed it, how it was made. How it was taken away from the fundamental right. Earlier we used to have by the Hadia judgment. This right to marry a person's right to marry a person of one's choice under Hadia judgment, it was made that it is a fundamental right. But under Supriya judgment, I remember the judgment now. Under this judgment, in 2024, it was made that it is not a fundamental right because there was a question about the homosexual legality of the homosexual marriage. That is something different. But here, what we are discussing, that this right to life or personal liberty, it does not only include that you should live, it includes that you should live with dignity. And how you can live with dignity? If you have the clean environment, if you have the health care, if you have the free legal aid, if you have the speedy trial, if you have the shelter, you have education, you have reputation, you want to sleep, you want to keep quiet, you don't want noise pollution there. So all these rights are derived from this Article 21. So this is what Article 21 is. Is it absolute? No, it is not absolute. What is the reasonable restriction to it? The reasonable exception or restriction to it is procedure established by law. A law can come in and it can, curb this right of yours. That we will discuss. What is the significance of it? We understood that. What is the significance of it in the discussion where we assumed that, let's suppose, there are no other rights except Article 21, and suppose there is all the rights are there but Article 21 is not there, how life would be. So at the end we concluded that this Article 21 is the soul of the part 3 and part 4 of the Indian Constitution. Now let's try to discuss what is the reasonable restriction to it. What is this do? Procedure established by law. Let's try to understand this concept. Then we will discuss few judicial judgments from the Supreme Court with respect to that, and how we change it from the procedure established by law to due process of the law. Here let's try to understand what is this procedure established by law. What is this procedure established by law? Let us suppose, I will give an example. Let us suppose there is a person who is minding his own business. He is running a shop, and a person and a police will come to his home. Police will come to his home and they will arrest him. Once he will be arrested, they will not inform him for what reason he has been arrested, and they will not tell him. Then somebody of his friend, they will put him in jail. Somebody of his friends will reach to the court. They will ask the court, sir, please bring this person here, issue the writ under Article 332 of the Indian Constitution, and ask the state why they had arrested him. Now the court will call police, tell them why you had arrested him. Now police can say that, let's suppose police will say that we had arrested him because we wanted to arrest him. The court will slap the police and tell them, get the hell out of here and leave this person. Because the Constitution, the Article 21 says there is a procedure established by law by which you can curb his fundamental right. His fundamental right is to run his business. His fundamental right is to be out of the jail. If you are curbing his fundamental right, there should be some procedure established by law. This can't be the reason that you had arrested him for no reason. No, this is not valid. Now, the police may say that, sir, this person has violated certain law. This person has violated certain law. Now the court will say that, what is the law, who was the authority who had made the law. Let's suppose this law was made by some, you know and this law was made by whom. This law was made by anybody, uh, ABC, nobody. He has violated this law of the panchayat. Suppose they had come up with the law that he cannot, suppose there was a law, there was a call for the hartal, there was a call for the hartal from the separatist leaders, and he has violated this call. Because of that, we had arrested him. The court will say, who are these separatist leaders to make any law? So this law should be made by whom? This law should come, if there is any law, it should be very much valid. It should be made by the authorities. Suppose if this law is about, if this law should have been made by the center and it is made by the state, then this law will be invalid. For example, we know the seventh schedule. In it, we have the certain items reserved for the center, certain items reserved for the state, and certain items reserved for the both to act together. So suppose there was an law made by the state in which they had interfered in the center's law, in the center's item they had made the law, and any person had violated it, and he has been arrested. Here the judge will say that who was the state to make the law about it? Please leave him, please let him go, because it is the procedure established by law has not been followed. So this is the second case. That first what they will check, first thing what court will check, whether is there any law for which he has been arrested, if is there any law. Second, whether the law is whether the institution who has made the law, who has passed the law, is is the competent enough, whether the institution second, whether the institution who has passed the law is competent enough to make the law. Here in this case, suppose some separatist leader has made the law, that won't be valid, so the police would be told to leave him. This is the second thing which would be judged there. Then what would be the third thing? Third thing would be the procedure mentioned under the law. Has the procedure mentioned under the law been followed? For example, he has violated, for example, this person, he has violated some law. He has violated some law, and the police came in. They informed him. In not in writing, but they just told him that we are arresting you for certain reason, and they took him in the jail. So the court will ask the police whether they had followed the procedure established by the law. They had followed the procedure which was mentioned under the law. Whether they had given him the reason in writing why he was arrested. So these three principles are checked under the procedure established by law. This is the restriction to article fundamental right, article 21. Suppose if you are being arrested, suppose if your fundamental rights are to be violated, you are under arrest, the court will ask these three questions. This is procedure established by law. If there is any law that you had violated. Second, whether the law which was violated was framed by the competent authority. Third, whether the procedure was established in your arrest, the procedure which was mentioned by the law, it was followed or not. Once all these three are ticked, once all these three are followed, then the court will say to you, sir, the court will say under this, the court will say you, sir, we cannot help you because there is a law, there is the procedure, and the law is also valid. Now we can't do anything. So this is the procedure established by law, and we had borrowed this procedure established by law from the Japanese constitution. Here there is a protection in the procedure established by law. You are protected against, judiciary protects you against whom? Against executive, but it does not protect you against the legislature. Now let us suppose there is a law, there is a law which says that if you are taken to jail, if you are arrested, there is a law. Suppose the parliament will come up with the law, legislature will come up with the law which says that you can arrest any person who is walking on certain street You can arrest any person who is walking on certain street, and you don't need to take him to the jail, you don't need to take him to the court. And this, you can file the charge sheet. For that you will have 3 to 4 thousand years time. Till this 3 to 4 thousand years time you can file a charge sheet. There is no limit on the time. Whenever you want to file the charge sheet, you can file it. And suppose under this law certain person is caught, certain person is is arrested. Now he will reach to the Supreme Court, he will reach to the court and says, I had been illegally arrested. Then the court will ask these three questions: is there any law? Definitely there is a law. Whether the law is given by the competent authority? Yes, it is given by the parliament. Third, procedure was followed, 100% procedure was followed. Then the court will say we can't do anything, because here we follow the law in letter and spirit. We follow the law, we have the procedure, we have the principle, that is procedure established by law. Here we cannot accept you, we cannot help you in any way, because we cannot protect you against the legislature. But in USA there is a different concept, which till 1976, till 1976, this is what was followed. Sorry, until 1978, this is what was followed in India. After 1978 the situation has changed. So till 1978 it was followed in India, that there is procedure established by law. Now we will shift to other, that is due process of the law, that we will shift. Now we will discuss what is this due process of law which is followed in USA, and how we had adopted this due process of law in our constitution too. We'll try to understand that here. Here, under procedure established by law, we understood that there are three things which the courts will ask. First, is there any law, whether law is valid or not. Third, was the procedure, where the rules followed while you were arrested. In the USA there is fourth term. What is that? Is this law justified? Is this law justified? It would be seen, this would be followed, this would be seen. Is this law justified? It would be seen in the USA, and we had adopted it since 1978. This fourth point, it will be also seen. So in nutshell, what is our what do we adopt right now? What we have right now, we have both procedure established by law as well as due process of the law. In the due process of law, we have this fourth term also, whether this law is justified or not. Now let's take an example from the USA itself. Yeah, well, there was a case about, there was a case, namely Lawrence versus the state of Texas. So state of Texas, if you would have heard about Texas, they are much Catholic Christians. They are Orthodox Christians, or we can say they are Catholic Christians there, and they follow, they follow Christianity to the maximum as compared to other states in the USA. When you have such religious community in a particular state, the laws which you are making, they are in line with those religious understanding. So there was a law which was against sodomy. About sodomy, you cannot have a sexual relationship from the backside. That is different. I hope you are very much aware of what sodomy is. So there was a law against sodomy, that you cannot have this the act of sodomy in that particular state. So what is this Lawrence versus state of Texas? Here the case was about two people who were holding hand in the market, and they were caught, they were booked under the sodomy act, and they were sentenced to the jail term. Then the Supreme Court intervened. Supreme Court said that even though there is a law from the Texas, even though the procedure was followed, even though the procedure was followed, there is law and the law is valid, but this law is not justified. We cannot justify this law because it is against the personal liberty of the person. It is against the personal liberty, that if you want to love anyone, you are adult, you have the consensual relationship, you can have it with anyone. So this came into existence, and this person Lawrence, they were freed, and this became the landmark judgment. that the justice, that the law should be very much justified. It should be very much justified. So till now we had understood that in India till 1978 we have procedure established by law. After that we had the what we had in a way followed, we had in a way accepted the due process of law. Now let's discuss few cases with respect to how. Now let's see how we shifted from procedure established by law to due process of the law. Let's try to discuss that. Let's try to map that out, how we shifted from procedure established by law to the due process of the law. Let's try to understand that through the judicial verdicts. The first case which we need to know here is about the A.K. Gopalan versus the state of Madras, and the year was 1950. Well, this A.K. Gopalan, he was a freedom fighter, we can say. At the time of independence, he was in jail. At the time of independence, he was in jail. When he was in jail, when we got the independence, he was celebrating with his fellow inmates, and he was expecting that he would be now freed. Once he was freed, he was arrested again many times. He was freed and arrested again. On what charges? On the preventive detention, that we will try to understand in Article 22. On the preventive detention, he was freed and again arrested, and freed, again arrested. So what he got frustrated and reached to the High Court. He reached to the Supreme Court, and told them, and he told Supreme Court that, sir, this is very wrong. This law, this preventive detention is very wrong, and it is violating my fundamental right. But here the court said that, sorry, we can't do anything with this, because there is a law, and there is the constitution. It says that due process should be followed, and this is exactly what the government is doing. They are following the due process, and so we can't help you in this regard. So here the procedure established by the law is followed, and this procedure established by the law was followed in this case, and eventually he was again arrested, and with this under the preventive detention. So he was the first victim of the procedure established by law. Then the second case which we need to know here is about the the Maintenance of Internal Security Act, maintenance, which is basically ADM Jabalpur versus Shivkant Shukla and ADM Jabalpur versus Shivkant Shukla. Here what the case is, basically in 1975, we know that how emergency was imposed, and here when the emergency was imposed, there was law was introduced which is named as MISA. What is this MISA law? What is this? Under this law, that it is the Maintenance of Internal Security. So under this law, the law says whoever is arrested under MISA, he cannot approach Supreme Court under Article 32. If anybody is arrested under the MISA, if anybody is arrested, they cannot approach Supreme Court. So they cannot approach Supreme Court for the revival of their fundamental right. So with this, this law actually went to the Supreme Court. It was discussed there, and the Supreme Court under ADM Jabalpur versus Shivkant Shukla judgment said that, we can't do anything, because this is the procedure established by law. We have this principle that the restriction to your fundamental right is the procedure established by law, and we know that under the procedure established by law, there are three conditions. There should be law. Second, it should be valid law. Third, the procedure should be followed, and all the three are followed. We can't do anything with respect to that. We can't discuss whether it is justiciable law or not, whether it is justified or not. That is something different. So here right now there is emergency and they can curb your fundamental rights to any extent. We can't help you with respect to that. And this case, it is also called the habeas corpus case, also called a habeas corpus case. So here it was a judgment till 1975. This was a judgment. After that, the court till now established what? Court established the procedure established by law. The courts in India, the judiciary in India, they followed this principle. That principle was procedure established by law. After that, in 1978, there was another case. In 1978, there was another case, namely the Maneka Gandhi versus Union of India. Her passport was seized by the government. So this case was in the court. And here, first time we saw that courts had tried to shift away from the procedure established by law to the due process of the law. It was the first time under the Maneka Gandhi versus Union of India in 1978. It was the first time that courts had started to shift from procedure established by law to the due process of the law. So here, the what was the question? That is not necessary. It was about her passport issue. It was curbed by the government. That is something different story. So what was the discussion given by the courts here? That is something which we need to understand, which we need to have the understanding of. The court said that this due process of the law, what it is, what is this due process of the law? It is something, there is something called the natural justice. There is something called the natural justice. And this natural justice, due process of the law and natural justice, they are very much, very much equal. Due process of the law is within the natural justice of the people. And this natural justice, if we will see, its reflection is seen in Article 14 of the Constitution. The reflection of natural justice, it is seen in the Article 14 of the Constitution. So under the principle of natural justice, the courts came up with, under the principle of natural justice, we have to follow the due process of the law. We have to see whether the law is constitutional or not. That is whether the law is justified or not. And here, with respect to Maneka Gandhi case, the judgment was very much different, which contradicted with the earlier judgments what courts used to have when such cases would come in the Supreme Court. So they changed their principle. It became now due process of the law because it is the part of the natural justice, and natural justice is reflected in Article 14 of the Indian Constitution. So what are the principles of natural justice that we need to understand here? First principle of the natural justice: nobody should be sentenced without being warned, without being heard. Nobody should be sentenced without being heard. You have to give him the legal aid for that. He should be given the right to have a legal aid. If he is not capable of appointing a lawyer, then give him this lawyer, so that he should be heard. His point of view should be heard. Why he is being arrested, why he is in jail, that should be discussed. So second principle is that no person should be judge of his own case. No person should be judge of his own case. This has to be looked into. And the third, the authority shall act bona fide. The authority shall act bona fide. These are the things which we look into, which the courts look into such case. In such cases where due process of the law is to be followed, first they will look into whether this person who is being arrested, whether he is being given the opportunity to be heard, whether he has been given this opportunity. Second, if if the case is against any judge, if the case is against any person, if the case is against the government, then that person against whom the case is, he should not be the judge of his own case. Then the third, if the law is made, whether it was bona fide, whether it was good or not, for example, whether the intentions were good or not. For example, tomorrow the government may come up with the law that you cannot slaughter chicken. There will be totally ban on chicken, and the reason would be given that because chicken are very much important, they, we cannot afford chicken, everybody cannot afford chicken. But the inferred idea behind that would be that it is to target certain people in our country. So these things would be checked by the court, whether this law, whether this whether this judgment, whether this arrest, whether any law, if given by the court, whether if any person accused under any law is in the court, these things would be checked, whether enough time was given to him, whether the reason for the arrest was given to him, whether he against why he has been arrested, should that person be the judge of the case, or the act which was formed by the court, whether it was in the good intention or in the bad intention. So finally this principle was adopted, that the due process of the law has been adopted in 1978. The fourth condition which we discussed, that would be checked whether law is justified or not. So this is so far with respect to Article 21, with respect to the right to life and personal liberty, and the exception due process of procedure established by law. And in this procedure established by law, we had added one more point, that is whether the law is justified or not. And who will check it? It is the courts that will check it if anybody would be under arrest. So these things are to be are to be followed in our country. Now here we saw that in the natural justice there is a principle. What is that? What is this natural justice? It is not defined by the constitution, but it is very much understood. There is something which is very much understood, that for example, sun rises from the east. It is very much understood. It is very much universal truth. Similarly, the natural justice, it is the universal truth. It is very much understood that these rights are there to the people when he is born. These rights are there. So this second in it, which we discussed, that no person shall be the judge to his court, to his case. Now let's try to discuss it with an example, because we had the example of it also. Let's try to discuss that, how the judiciary has reacted to it. Let's try to understand that. You would have heard about Justice Rangan Justice Ranjan Gogoi. You would have heard about him. Now let's discuss a little story. Actually in today's daily current affairs, we discussed an article in the Hindu newspaper which was talking about we are serving the justices, not the justice. And in that article, this example was also highlighted about the Justice Rangan Ranjan Gogoi. What is the story behind him? Let's try to analyze that. In 2017, he was the part of the collegium, and there are 4 judges part of the collegium with the CJ of India. So these 4 judges, what they did, they decided to revolt against the then CJI, which was Deepak Misri. Deepak Misri was the Chief Justice of India at that time, and these 4 judges decided to revolt against him. And what were the allegations against the Chief Justice? Allegation was that there is bench fixing. For example, if there is any case against the government, then the Chief Justice of India, he appoints he fixes the bench, and he would fix it in a certain way that such cases would be given to a certain judge who is little bit biased towards the government. So this was the allegation, that there is a there are allegations against Deepak Misri, who was then Chief Justice of India, that there is the bench fixing allegation. So they first revolted against the CJI. He did not hurt them, and they called the media. For that, and they highlighted the issue and told the people that democracy is under threat. So this was the case, and for this case, this Mr. Ranjan Gogoi, he was highly appreciated Why he was highly appreciated? Because he was the second in line to be the Chief Justice of India. After Gogoi, he would have been the Chief Justice of India, and it is the current Chief Justice of India who would recommend who will be the Chief Justice of India after him. It was Justice Ranjan Gogoi who was to be the Chief Justice of India. So here what happened that he revolted against him, and eventually he became the Chief Justice of India. But after some period, there was a lady, there was a lady in the office who accused Justice Ranjan Gogoi against of this sexual harassment, or we can say sexual assault. He accused him of the sexual assault, and his husband was in the police. He was suspended, and she had faced a lot. Whether the case is right or not, that is something different, but here we are trying to understand what this concept of a person can't be judged in his own case. So when she accused him of the sexual harassment, sexual assault, the case went to the court, and it was heard by whom? It was heard by this Justice Ranjan Gogoi. He set up a bench. He set up the bench, and for that bench he chose two judges. He chose two judges to hear the case, and before hearing the case, he accused her of the falsehood. After this case was heard, there was a person, namely Prashant Bhushan. There is a person, namely Prashant Bhushan. He approached the Supreme Court and said that, sir, how can these two judges hear the case which was chosen by the Chief Justice of India, against whom the case is actually? How can these two judges hear this case? Then the Supreme Court said they made an important assessment here, that this principle, the principle of natural justice, where we saw that a person can't be a judge in his own case, this does not apply to the Chief Justice of India. So this is the principle of natural justice. This is what we had understood so far. So here earlier, now let me recap what we discussed so far. Let me recap that. Let me rub it first. First, we discussed Article 21 of the Indian Constitution. We started that what Article 21 is. It is not just bare breathing, physical breathing, but it has a wider scope, and it has been interpreted by the judiciary in different ways. Judicial creativity we had seen in it, and we had been given various rights under Article 21, which were not in letter, which were not actually the part of Article 21 in the Constitution, and it has the wider scope. After that, we saw that even though there is a wider scope, what is the significance of Article 21? We saw that how it is important. If there are no other fundamental rights, but Article 21 is there, that is everything we have. Judiciary can use the judicial creativity, and we will get all the other rights. But if Article 21 is not there, then there is a problem. But after that we saw that this Article 21 is not absolute. It has the it has restriction. And what was the restriction? It is the procedure established by law. Then we started to understand what is this procedure established by law. Can anybody arrest me for no reason? Then we saw that what are the conditions, what would be asked, under which law you had arrested certain person, had you followed the procedure established, is this law valid? Second, is this law was this law made by the competent authority so that it is valid? Third, we saw that whether the procedure was established which was given in by the law. This is what we used to have till 1978. Till 1978 we used to have this procedure established by law. But after 1978, in Menaka Gandhi case, we saw that the judiciary has expanded the scope of this Article 21, and they had shown they had established that Article 21 under this article, it does not mean that it is only the procedure established by law. We can also see under which law you had been arrested, whether that law is justiciable or not. So in a way, we follow the due process of the law from 1978, and we had seen that in the Menaka Gandhi case. And why this due process of law was established? Because according to the judgment, that it is very much part of the Article 14. It is the due process of the law. It is very much part of the very much part of the natural justice, and natural justice, is very much part of the article 14, because it is against the arbitrary nature. Anything which is done arbitrarily, that is against article 14, and this natural justice is very much part of it. So under natural justice, we have to follow the due process of the law. It was established, and then we saw that what are the key features of the natural justice. We saw that first, that two important points about the natural justice. We saw that first thing, that nobody should be sentenced without being heard. If you have to sentence anybody to the jail, you have to hear him. Why he has done it, whether he is innocent or not. Second, we saw that no person should be judge of his own case. Then we saw with respect to that how Justice Ranjan Gogoi, his controversy. We saw that how he refused to be the judge of his own case, but he chose to other judges to hear that case, and the matter went to the court again, and the court said that there is exception for the Chief Justice of India. Then third, we saw that the act shall act bona fide. The authority shall act bona fide. You cannot make any law target any society, any part, any particular religion. You have to have the good faith in it. There should be the good faith in it. This is what we learned so far in under article 21. So till now there is another question. Right to life. We discussed that right to life is a fundamental right. Does it mean that if right to life is a fundamental right, then right to die should also be fundamental? Then if right to life is a fundamental right, then right to die should also be the fundamental right. If what does the right to life mean? That you should live with the dignity. If this dignity is not given to me, suppose I'm not in a position, my reputation is down, I have zero reputation, I have no access to education, my children are not able to feed enough, I'm not even able to feed my children, I'm not even able to run a business, I'm very much restricted. Then would I not prefer to die rather than live, because I am not enjoying the dignity which the article 21 gives to me. So this question was, this question, whether right to life, if right to life is a fundamental right, then right to die should also be the fundamental right. So with respect to this, we had the section 309 of the IPC. Under this section 309 of the IPC, if there is a person in our country, he has attempted to do suicide, it would be very much criminal in nature. Now how he would be tried under the court, how it would be, how it is an criminalized act. Suppose if he attempted to kill himself, but somehow he did not die, then he would be accused of the crime, and it was very much criminal under IPC 309 of the IPC. Under section 309 of the Indian Penal Code, it was very much criminal. Then the matter went to the court. Under the Rathinam case. Under Rathinam case, the matter went to the court, and it was said that the same argument, if a right to life is a fundamental right, then right to die should also be the fundamental right. Right to die with the dignity should be the fundamental right. And it was established under this case that this section 309 of IPC is unconstitutional. You cannot criminalize the suicide. If anybody saves his, does not die of the suicide, you cannot criminalize it. But 2 years later, it was overturned, that it was established that right to life cannot be equated to right to die. These are two separate things. So with respect to this, let's try to discuss another point which we need to know under this, and the concept is euthanasia. What is this euthanasia? Let's try to understand that. Let's try to get the idea of that, what this euthanasia is, and then let's move forward. There was a lady, very unfortunate lady, I would say. Her name was Aruna Shanbag. Unfortunately, she was a nurse in a hospital, and one of the male member you know, he was not happy with her. What he did, he assaulted her. And this person, this Aruna Shanbag, she went to the coma and then to the permanent vegetative state. That is, she became brain dead. When any patient is under the permanent vegetative state, if any patient is brain dead, then his recovery becomes very much difficult. It is almost impossible to recover that patient. If anybody is in coma, that can be recovered, but if anybody is in the permanent vegetative state, that person, it is very hard to recover that person. So when she was brain dead, she had a friend, and her name was something Pinky. I don't remember her name properly, and that is not the point of the concern here. What she did, she approached Supreme Court. When she approached the Supreme Court, she told the Supreme Court that, and this thing happened in 1973. So remember for how long she was in the vegetative state. She approached the Supreme Court and said, Supreme Court, sir, what does the right to life mean? Does it only mean bare breathing or right to dignity? Supreme Court said it is the life with the dignity. Then she asked this question, where is the dignity of Aruna Shanbag? She is not even able to change her clothes. She is not even able to, style her hair. She is not even able to eat by her own. She is on the ventilator, from last 20 to 30 years. Please give us the authority to kill her. Please give us the authority to kill her. So this was the question raised by her friend, and this question was opposed by the nurses in the hospital. They said that, who is this Pinky? Who is she? She is nobody. We are taking care of her. We will not let her die. Look at her body. She don't even have a bed sores. Look at how much care we have taken her. So please do not listen to her, and do not listen to her in any way. So here the courts established a principle. What was the principle established? Courts differentiated the euthanasia. Euthanasia was differentiated, and it was differentiated into two parts. One is the passive euthanasia, and second is active euthanasia. What is this active euthanasia? For example, if you are suffering from disease but you are able to take your decision by yourself, you are suffering from any disease, you are able to walk, you are able to eat by yourself, you are able to see, you are able to talk. Suppose you are in the sixth stage of the cancer, but you are able to talk, able to walk, able to do everything. So here, but you are suffering certain large amount of pain, you want to die. For that, injection is needed so that we can kill you. The outside source is needed to kill that person. This active euthanasia is not allowed in our constitution, in our country. What about the passive euthanasia? Passive euthanasia is, suppose there is a person who is on the vegetative state, who is on the vegetative state, who is brain dead, who is under the permanent vegetative state. For such persons, they require the life support. They require the support of ventilator. For such persons, if the courts will agree, this life support would be switched off, and eventually they will die naturally. So this passive euthanasia was allowed. But here in this case there was a concern. What was the concern? That this decision should be taken by the family of the patient, but this lady, she did not have the family. This Aruna Shanbag, she did not have the family. If she does not have the family, then the next friend should take the decision. Next friend. Now here was the discussion, who is the next friend of this lady. The discussion went to the court, and finally court decided that it is not the Pinky who is the next friend, but it is the nurses who are taking care of her who are the next friend. And nurses did not agree for her passive euthanasia, and eventually in 2015 she died. So here what did we establish from this case? That dying, if you have the right to life, similarly right to die with dignity is a fundamental right. After that, we have the concept of the written will, the concept of the written will, and that also has become the fundamental right. For that we have the Rohit Bal case. There was a dispute over his property, and who would be the who would be the right candidate for his property. It was the dispute between his boyfriend, and his brother. So there was a dispute over his property, and in this judgment, the point was established that in fundamental rights, the right to make a writ, a right to make a will, right to have a will, is also a fundamental right. But this will, there are certain conditions to be followed. First, it should not be the person who is making the will, he should be of the sound, he should be of the sound mind, his mind is working properly, and there is a witness to this will that he was not forced to make such will in any pressure. So this is what article 21 says. Now, till now I hope you had understood the article 21. Now let's move towards the article 21a. Let's try to understand that what does the article 21a say, and after that we'll move towards the article 22. So till now I hope this is very much clear, what article 21 says. We had understood it, I hope so. If there is any confusion, please do write in the comments. We are here to help you. Now let's have a look at article 21 clause a, the amendment which was made to it. Here we saw that, here in this slide, we saw that we had been given many fundamental rights in I guess in 1993 the Supreme Court said that it expanded the scope of article 21, and said that the right to education is also a fundamental right. So this was expanded, but in 2000, in 2002, through the 86th Constitutional Amendment Act, it was introduced. Article 21A of the Indian Constitution, it was introduced, and what does it say? It is a fundamental right that mandates that the state has to provide free and compulsory education to all children between age group of 6 and 14 in such a manner as the state may by law determine. So because of this article 21, it was made the fundamental right. It was given a separate space in the constitution under article 21a of the Indian Constitution, that it is a fundamental right and the state may provide free and compulsory education to all children between the age of 6 and 14 years in such a manner as the state may by law determine. So why it was introduced in here? Like as we said, that as I already told you, article under article 21 there was a scope of the marriage in it, that it was considered that it is a fundamental right until Hadia judgment. But in 2024 we have the Supriya judgment, where it was established that it is not a fundamental right. So what is a concern with respect to judicial pronouncements? Judiciary may decide certain act as a fundamental right, but if it is not in a constitution, if it is not amended in a constitution, then it becomes very much volatile. In second judgments, judiciary may change it, but if it is written in the constitution, if the legislature will bring it in the constitution, then to change it you need a constitutional amendment act. So it gives it a further protection. That's why it has been added into it. And what does the article 21a say? That it is a fundamental right. It mandates that state shall provide free and compulsory education to all children between the ages of 6 and 14 years. Earlier it used to be in the part DPSPs, but in 2002 it was given the scope of a fundamental right, and it was brought in the part 3 of the Indian Constitution. So as we can see here it is one thing is mentioned, in such a manner as the state may by law determine, and it was determined by what law? Right to education law. In it there were certain provisions which were to be followed. First, let's try to understand the provisions here under the right to education law. Under the right to education 2009, what were the provisions? First, continuous 8 years of schooling should be there. Continuous 8 years of schooling. Second, no child can be denied admission for the want of documents. For example, Government schools cannot have the excess burden on the child that they shall have all those documents, passports and all that to get the admission. No, this can't be done. This burden of documents can't be the reason for not access to the school. Third, ensure that they attend the school. For third, the government school, the schools have to ensure, the state has to ensure that whether once the students get admitted, they attend the school properly. And for that we had seen various schemes brought in by the government. For example, the midday meal, the children will come for the food and we will teach them there, and various other schemes had been brought by the government. Similarly, another thing which was introduced, that there should be no detention policy. You cannot fail a child from the age, from this age group, from these classes. You cannot fail a child, but it was highly misused. Because of this no detention policy, it became that no teaching policy, and students, they knew that they won't be failed, so they started leaving the schools. So it was misread. Actually, there was with respect to no detention policy, there was an additional thing which was called the continuous comprehensive evaluation. Continuous comprehensive evaluation, it should have been there, but it was not totally added. So no detention policy was adopted by the states, and because of that, students, they started not to go to school, and the level of education dropped. And it was very much highlighted by the ASR report, which is given by the Pratham NGO. And under this report, it was highlighted that how the class 5th student, class 6th student cannot do even the maths, even the basic calculations, which a class 2nd student should be able to do that. This impacted, this no detention policy, it impacted the education system in our country, especially in the government schools. But at the same time, we have to understand why it was introduced. It was introduced because if you are going to fail a student, he will remain in the same class, and it will have a psychological impact on him that his friends are moving to the another class, but he is in the same class. Because of that, he will have this psychological impact. He will get bullied by the other students, and finally he will leave the school. The prior need of the time was that students should visit the school, they should come to the school. So that's why this no detention policy was adopted. But further, the states are moving away from the no detention policy, and now almost every state has moved away from it. And after that, another thing was adopted here, which is 25% seats should be reserved for the economically weaker section people in the private schools. These 25% seats should be available for them, so that they can get the better education. But it was also criticized. Why it was criticized? Because it has various ideologies behind it. First, if a student from a economically weaker section will go to the private school, the students in those private schools would be from the high value families, they would be from the rich families, their lifestyle would be different, their lunch boxes would be different, their food would be different. And when these poor people will go to there, these poor students will go through there, they will start acknowledging this this class gap, and it will in a way have a psychological impact on them, and they will feel less about themselves, they will lose their self-esteem. It was one of the reason which was highlighted. And also it may impact the business of the private schools. So this is also one of the criteria to be introduced in it. So these were the key provisions which are to be followed under this. So by this we had completed article 21. Article 21, what does it say? We understood that. Article 21A, it is about the fundamental right, providing the free and compulsory education to all children between the ages of 6 to 14. Why do we need this article? If we want to enjoy the article 21, if we want to enjoy the life of dignity, for that we need education. Why we need education? To get the job. If we have the job, then only we can have the dignity. If we have this understanding, if we have this intellect, then only we can enjoy the dignity. And this was in addition to that. So after this article 21A, the Right to Education Act was introduced, and these were few provisions which we discussed here. Now with this, I hope you had understood article 21 in very much detail. Now let's move to the article 22. Let's try to understand that. Here, what does the article 22 say? Article 22 says, as it is highlighted here, that Article 22 of the Indian Constitution deals with the protection against arrest and detention in certain cases. There is a protection against arrest and detention in certain cases. It aims to safeguard the person's liberty of individual from arbitrary and excessive exercise of power by the executive. This article provides certain procedural safeguards to persons who are arrested or detained. What are these procedural safeguards? Deals with the rights of persons arrested under ordinary law. Second, deals with the provisions of the for the preventive detention. Now, what are this? What are the we know that this Article 21, it is against protection against arrest, and detention in certain cases. This article basically it activates after you are being arrested. There are certain things which are to be looked after. Once you are arrested, there is definitely the you should be told why you are arrested. This right is given to you by the Article 22. Why you are arrested? If you want an legal aid, this legal aid should be provided to you of your own choice. No person shall can detain this. No authority can detain this from you. There would be the legal aid, and this why you are arrested, it is to be told to you, and it should be told in the written form, so that you can give it to your lawyer, and he will look into the matter why you are arrested and what can be the solution to that. But and after that, when it is given into the written form, then you should be, it is mandatory for the authorities to bring you to the judicial magistrate, to bring you to the judicial magistrate within the 24 hours. Within 24 hours you have to be brought to the judicial magistrate. He will look into the matter. He will look into within 24 hours. If you are detained, if you are detained of any crime, you would be told the reason for that. You would be given in the written form. You will be given the you will have the opportunity to choose the legal aid for yourself, and you would be brought in front of the judicial magistrate, and the judicial magistrate will look into the matter, whether it is legal or not, and then he will send you to the either to the police custody or judicial custody. So what is the difference between the police custody and judicial custody here? This police custody, it will, if you are in the police custody, so you will be in the police lockup. You would be held in the police lockup, and once you are in the police lockup, then police can investigate, interrogate you. They can say whatever they want. They don't need any permission from the judicial magistrate. But if you are in the judicial custody, you would be sent to jail, and if the police wants to consult you, for that they will have to ask the permission of the judicial magistrate. So this is the difference, and it will be decided by whom? It will be decided by the judiciary. And these rights are given to you by whom? These rights are given to you by the Article 22 of the Indian Constitution. It gives you the protection against the arrest and detention in certain cases. It aims to safeguard the person's liberty of individual from arbitrary and excessive exercise of power by the executive. A policeman cannot come to your house and arrest you for no reason. That is the arbitrary, for arbitrary reasons. Without any reason, he will come to your home and arrest you. When he has to take you to court within 24 hours, or if he will not take you to the court, then somebody will go to the court on your behalf, and he will issue then the court will issue a writ for you to have you in the body, and they will ask the executive why you had arrested him. Then if the executive is not answering according to this act, according to this article, then there would be the actions against him. So this gives you this protection against against arrest and detention in certain cases. But definitely, even if you have this protection, we have to understand that this protection is not an absolute one. There should be, there is definitely there is some exceptions. What are the exceptions? Let's try to understand. The exception here is about one of the exception is enemy alien. For example, right now, if we are in the war with Pakistan, if their citizen is in our country, then we can arrest him. We don't need to bring him to the judicial magistrate. We can arrest him for as long as we can. There nobody is going to ask us the questions. That is the enemy alien. But if he is the alien from another country, friendly alien, then for that it is not valid. Then the second exception is a person arrested or detained under any law providing for the preventive detention. If it is for the preventive detention, then this is the exception. Suppose if they, let's suppose what the preventive detention says. Detention, suppose if the executive, if the police will feel that if there is a certain person who is under their radar and they feel that he will do certain crime, he is a politician, he is a separatist. Suppose we saw that in 2018, sorry, in 2019, how the statehood of JNK was revoked. Before that, all the leaders in JNK, they were arrested. We saw that arrest of the mainstream political leaders as well as the separatist political leaders. When they were arrested under preventive detention. So why they were arrested? Because the state knew that if they will not be arrested, and once we will revoke the article 370 of the Indian Constitution, article 370, once it would be revoked, they will go mad, they will go for the hartals, there would be chaos in this state. So to prevent that, they had been arrested, and this preventive detention, it is an exception to article 22 of the Indian Constitution. You can do it, but here still it can be misused. For that, within 3 years, within 3 months, you have to within 3 months you have to approach the for the maximum period of 3 months you can be arrested under it. Then after that, it is the advisory board who will decide about the matter, whether this person should be arrested or not. This advisory board will decide. For 3 months you can arrest him without any reason. After that, it is the advisory board that would decide whether the arrest is legal or not, whether we should continue the arrest or not. So this is the preventive detention, that the state is preventing you from doing any crime. The state is preventing you from doing any crime. The detention here, it is of two types. One is preventive, another is punitive. This punitive is once you have done the crime, you are arrested. Preventive is the state is protecting you from doing any crime. So this is how it works. This is what Article 22 says. Article 22 says that you had the right. Article 22 of the Indian Constitution, it deals with the protection against arrest and detention in certain cases. It aims to safeguard the personal liberty of individual from arbitrary and excessive exercise of power by the executive. This article provides certain procedural safeguards to persons who are arrested or detained. These provisions, whether you are arrested for what reason, all that stuff should be given to you, and you should be brought within 24 hours to the magistrate, and magistrate will decide about your detention. But there is a exception. What is the exception? If you are an enemy alien, that is the exception. Or if you are being arrested or detained under any law providing for the preventive detention, then this is the exception. So we here understood what preventive detention is, and also Article 22 of the Indian Constitution. With this, I hope both the articles are cleared. For today's discussion, Article 21 is very much clear, and Article 22 is also clear. Now let's try to solve these questions here. The question says, which of the following rights have been interpreted by the Supreme Court of India as its integral component of right to life and personal liberty under Article 21 of the Constitution? First, right to life, livelihood, correct. Right to privacy, correct. Right to a clean environment, correct. Right to die with dignity. Right to free legal aid, correct. All the 5 statements are correct. So these are interpreted by the Supreme Court of India as integral components of right to life and personal liberty. Now let's move to the last question of today's discussion. It says, with reference to Article 22 of Indian Constitution, which of the following statements are correct? First statement, it provides safeguards against arbitrary arrest and detention under ordinary laws as well as the preventive detention law. 100% correct, but there may be exception. A person arrested under ordinary law must be produced before magistrate within 24 hours, excluding the time necessary for the journey. 100% correct. Within 24 hours, you have to produce him before the magistrate. But you can exclude the time which was spent in the journey, because sometimes you may have to travel many kilometers, and it would be practically impossible to produce the person within 24 hours. So this is excluded in it. Third statement, the safeguards of informing grounds of arrest and legal representation do not apply to an enemy alien. 100% correct. Fourth, a law providing for the preventive detention can authorize detention for a maximum period of 3 months without the opinion of an advisory board. 100% correct. This is also true. So with respect to this question also, the correct statements are statement 1, statement 2, statement 3 and statement 4. Sorry, the statement 1 is incorrect because this is particular to ordinary laws. Incorrect. So the correct answer is option B. So with this, with this we complete our today's discussion. I hope you would have liked the video. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Now statement 1 is also correct because preventive detention in certain cases it is that would be the exception, not always. You cannot you cannot arrest anybody. If you cannot arrest anybody you want, but there should be certain cases. Definitely this is also true. So the correct answer to it is option D. Sorry. With this, I would like to thank you for staying with me. Thank you very much and have a nice day. If you like the video, please do hit the like button, do share it with your friends, and definitely do subscribe the channel. Thank you very much.